thank everyone for their time sharing with us today. I know all of us have other important things, but this is a very important session that we're glad we're able to bring forth today. My name is Brady Augustine, and I serve as a health policy director at Applied Policy. Applied Policy kind of focuses on trying to help healthcare organizations navigate a very complex environment. Healthcare is way more complex than it should be, but that's job security for many of us, right? It's almost perfect today that we are going to be talking about the No Surprises Act in the, the Halloween edition of the North Virginia Health Policy Forum. For those of us who may be skittish, during the last few months, the federal government has issued implementing rules for the No Surprises Act, and they're applicable rather quickly for plan and policy years beginning January 1st of 2022. The legislation and the implementing rules are going to have a major impact. Many of us work on health policy issues that are not directly related to us personally, but this one will impact all of us. And for example, just about everyone knows someone who's got a surprise medical bill that was kind of shocking. Imagine you go in for a procedure and you pay off the facility fee and you pay off the physician fee, and you're all happy and think you're done. And about 2 weeks, 2 months later, sometimes you get a bill from someone you don't even know. And that happens all too often. And I think the studies at CMS cite are about 1 out of every 5 ER visits and 1 out of every 6 visits in general to inpatient hospitalizations. So we're going to talk about 2 particular things. We're going to talk about balance billing, and we're going to talk about surprise billing. So though all federal programs in 18 states have prohibitions against surprise billing and balance billing, numerous studies and reports have found that the problem still exists in those areas that don't have protections, and the No Surprises Act was meant to address and fill these gaps. So joining us today are 4 people who are intimately involved in writing and leading the writing of the implementing rules for the No Surprises Act, and who can shed some light on this very complex and very important issue. So with that said, I'm going to introduce the team of presenters, and then I'm going to hand it over to them to kind of walk through some of the complexities and share some information. So first off, from CMS, one of my favorite acronyms. In fact, I think everyone who gets an MHA degree or MPH degree needs to have an acronym test. And one of my favorites is CCIO, which is, and they should know what it stands for, right? The Center for Consumer Information and Insurance Oversight, and the Centers for Medicare and Medicaid Services. So from CCIO, we've got Deborah Bryant, and Deborah works, she works as a senior advisor in CCIO, where she provides policy and strategic guidance for expanding consumer protections in the private health insurance market. And then previous to this, she spent her career in public and private sector supporting national and state level healthcare quality and access issues. She got her BS and MPH from BU, from Boston University. Next from CCIO, we've got Lindsay Murtaugh, who is the director in the division, right? Director of the Market-Wide Regulation Division within the oversight group in CCIO. Prior to this role, she served as a senior policy advisor in CCIO, and Lindsay earned a MPH, as I'm going to test myself here, MPH and law degree from Harvard. And then next, from the Department of Labor in EBSA, which would be another, quiz question, the Employee Benefits Security Administration. And so they're kind of in charge of the RESA law and many provisions, and have been highlighted significantly since the Affordable Care Act got put into place. So Elizabeth serves as the Deputy Director for the Division of Regulations and Standards within the Office of Health Plan Standards and Compliance Assistance. So Elizabeth manages projects and what we call sub-regulatory guidance affecting group health plans under RESA. He participates in the tri-department team, which is Department of Treasury, Department of Labor, and Department of HHS. And then that is responsible for implementing the No Surprises Act. She is a graduate of the University of Maryland School of Law. And then finally, from the U.S. Department of the Treasury. We have Matt Muma, who serves as an attorney advisor in the Office of the Benefits Tax Counsel within the Treasury's Office of Tax Policy. He provides advice on matters related to health and welfare benefits. Before joining the Department of Treasury, he was an attorney in private practice, focused on health benefits issues. He's earned his law degree from the University of Michigan. So thank you all for joining us today. We'll begin with short opening statements from each of our guests, and then we'll move into the Q&A portion. So Matt, I believe you were on deck to go first, and we appreciate it, sir.
Thank you, Brady, and thank you, Brady, and good afternoon to everybody. Just before I start, just let everyone know, any opinions I express today are my personal views or this administration. And so to kick us off, I wanted to take us back to the first interim final rule published on July 13th this summer, and what it did as applied to payers, so plans and issuers of group and individual health insurance coverage. And so what the first interim final rule does is it prevents surprise billing or balance billing for emergency services by requiring in-network treatment by payers. It requires the same in-network treatment and prevents balance billing for certain out-of-network services provided by other providers at in-network facilities like hospitals or ambulatory surgical centers. And it prevents balance billing along the same terms for air ambulance services. Now, important to how payment disputes or payment determinations are made under the law, the first interim final rule set out a methodology for setting the qualifying payment amount. The qualifying payment amount is used to set patient cost sharing by payers in the circumstances I described a second ago. And in states that don't have a all-payer claims database or a specified state law, which would set payment rates in billing disputes, the qualifying payment amount can travel through to the independent dispute resolution process, which my colleagues will describe in a minute. So it's a very important number. The qualifying payment amount is intended to correspond to the median payment rate for in-network contracts from payers from 2019 as indexed for inflation. And in situations where such a rate may not be available, it specifies when databases may be used to fill in gaps where a same or similar item or services numbers may not be available. And it will be set at the level of markets, geographic regions, based on where an individual service took place. The first interim final rule also did a couple other things. For example, it recodified some previously existing patient protections and expanded those protections to grandfathered plans. And one important thing to remember regarding to how the qualifying payment amount is set is that, as I said a moment ago, it doesn't apply to all items and services. Instead, it will apply only to those for which a specified state law or payer claims database doesn't apply, and that applies at the service level. So I understand that CMS is currently working with the states to work out when a state law would apply to a particular item or service and when the federal law would apply. And finally, before I turn it over to my colleagues, the first interim final rules set out a complaint process by which members of the public and providers can alert the departments if payers and plans and issuers are not complying with the law. So it sets out this overarching process for preventing surprise medical bills and a methodology that's very important for setting the qualifying payment amount. And with that, I'll turn it over to Lindsay for some information about the requirements on providers and facilities.
Thanks, Matt. And so I'm going to also provide a disclaimer as Matt did. I'll actually, I think, go ahead and provide it on behalf of Deborah and Elizabeth as well, since it'll apply to all of us. But done that, let me jump into it. So in addition to the requirements in the first interim final rule that addressed the requirements on plans and issuers, the rule also included a number of parallel provisions applicable to providers and facilities, since these rules go hand in hand. If the planner issuer has certain requirements and the provider or facility cannot balance bill in those circumstances. In the IFR 1 basically says that in the circumstances where balanced billing applies, providers and facilities to whom these rules are applicable cannot balance bill and cannot charge anything more than the cost sharing that is determined in accordance with the rules applicable to the plans and issuers. So that's sort of how they relate. And then it sets up some exceptions in addition to this. So generally, in the context that Matt just talked about, so emergency services and non-emergency services at certain facilities, the balanced billing protections will apply unless the individual provides notice and consent saying that they are willing to be balanced billed. And that is only available in a few circumstances. So if somebody is receiving an emergency service pre-stabilization, if they're receiving an air ambulance service, or if they're receiving certain services from ancillary service providers, the balanced billing protections will always apply. In the other circumstances, so that would be emergency services that are in the post-stabilization context, or for non-emergency services that are not provided by an ancillary, that are not considered ancillary services, the individual can provide notice, can receive notice from the provider or facility about the balanced billing protections and can opt out of the protections. They can say, okay, you know, I know you're out of network. I know I might get a bigger bill, but I'm going to consent to that. And we think that this is an important part of the law because it means that it could allow somebody to choose to go to an out-of-network provider who might not be otherwise willing to see them. I would note, though, that that option is not available for items or services that are furnished as a result of unforeseen urgent medical needs. So if somebody provides their consent to be balanced billed, and then something goes wrong, there are complications, even if they provided consent to be balanced billed for that original underlying service, they cannot be balanced billed for the additional items or services provided as a result of unforeseen urgent medical needs. With the IFR 1, we released two pieces of guidance. One of them is a mandatory notice and consent form that has to be used by providers and facilities when they seek this sort of consent. The rule in IFR 1 breaks down the notice and consent requirements slightly differently for non-emergency services and for post-stabilization services. I'm happy to address more questions on this later, but I just wanted to flag that at this point. Within the post-stabilization context, there are additional conditions that have to apply in order for the individual to be eligible to waive balanced billing protections. For example, they have to be able to travel to a participating facility. There are certain requirements that we've put in place to ensure that they can provide consent that's truly voluntary. And then the notice and consent requirements for both require certain things like that the consent be provided in accordance with certain timing requirements and the rules, that certain content information go into the forms, and that it also be available in the 15 most common languages in the geographic region. All of these go towards making sure that the individual is actually able to provide voluntary consent and informed consent. There's also a provision in the rule that the individual can revoke consent, so they could change their mind and say that they don't want to be balanced billed. And then there's also a requirement separate, that's a little bit separate from these balanced billing protections, that requires providers and facilities to disclose information about these balanced billing protections to ensure that individuals are aware of them. And this, we think, is very important to ensure that individuals aren't unknowingly or aren't balanced billed when they're unknowingly protected. So the rule addressed the requirements for providing that disclosure. It has to be done on a website, publicly posted, and also provided to certain individuals who are covered under these protections.
Elizabeth,
go ahead,
can I just only because I got a question from someone in the audience. And so if you can give me just a minute, I want to explain, I think, because we deal with balance billing all the time. We know what it means. I want to give a quick description, as low a common denominator as possible, to kind of explain what we're talking about, if that's okay with you, Elizabeth. Okay. So as we know, group health plans and issuers build delivery networks, right? They work out contracts with participating providers. And so when they have that contractual relationship with a participating provider, they're called in-network. Those providers that do not have a contractual relationship with the health plan or issuer are referred to as out-of-network. In-network physicians and facilities are paid at a maximum allowable rate. Those that are outside of the network tend to submit charges for procedures that are done, services and procedures that are done for beneficiaries of a particular health plan. And so what we're talking about here when we talk about balance billing is, assume the case that you're traveling and you end up going into an emergency room that's not in your health plan's network. You could get a bill based on charges, which is significantly higher than your in-network rate. And so your health plan would pay up to the maximum allowable. The difference between that amount and the charges is what you as a patient typically and historically have been responsible for. And the protections that we're talking about today are trying to take patients out of the battle between providers and plans and issuers and having them negotiate between themselves about payment. And that's why they're so powerful. The even more, I guess, insidious example is surprise billing, where, for example, a patient goes into in-network hospital. The patient did all their research, found the right facility, expected not to receive, crazy bills. And then after they have the procedure, they get a bill from someone out of network operating in the in-network facility. For example, a surgical assistant or an anesthesiologist. And so that's one of the things that has really upset patients and kind of led to the No Surprises Act in the first place. And so, Elizabeth, I hope I did it justice to kind of level set and clear the way for you.
You did. Thank you, Brady.
All right.
And thank you, everyone, for having us here. So I'm going to talk a little bit about IFR 2, which builds on IFR 1 to continue implementation of the No Surprises Act. In particular, IFR 2 builds a new federal independent dispute resolution process, IDR process, that will be available to plans and issuers, as well as providers, facilities, and air ambulance service providers to basically settle disputes on what should have been the appropriate out-of-network rate. So this rule is similar to IFR 1, an interim final rule. And so the comment period is currently open until December 6th. So if anyone has not looked at the rules, I recommend that you take a look and submit comment if you choose to. So basically the federal IDR process may be used to determine the out-of-network rate for emergency services, non-emergency services furnished by non-participating providers at participating facilities, and air ambulance services furnished by non-participating providers of air ambulance services when there isn't an all-payer model agreement or a specified state law that is applicable. The IDR process is available for settling disputes related to not only single payment disputes, but also bundled arrangements, as well as batched items and services. But in order to initiate the federal IDR process, the private parties, the payers and the providers, need to engage in what we call the open negotiation process. So this will be a 30-day process where the private parties try to work in good faith to settle their dispute. At the end of the 30-day period, if the private parties are unable to reach an agreed amount, then they may initiate the federal IDR process. Once initiated, the process allows for selection of a certified IDR entity. And once that IDR entity is selected, they will have 30 days to make a payment determination. The rules lay out certain standards related to making that determination. It basically provides that the IDR, certified IDR entity must select an offer that is closest to the QPA. It also provides that the IDR entity must consider additional factors if they are credible and submitted by the parties. And at the end of the 30-day period, the IDR entity must provide a written determination of their decision. If they choose to not select an offer that is closest to the QPA, then that written determination will have to explain why they deviated from that approach. The rules also set out several standards that are very detailed that certified IDR entities must meet. The rules contemplate an application process, which we are actively in right now, where arbitrators can submit an application to the departments seeking to be a certified IDR entity and showing that they can meet the standards. Some of these standards relate to financial solvency, conflict of interest, the ability to collect fees, the ability to really protect sensitive health information. And so, you know, the certified entities who are seeking to be certified will have to submit their information to the departments. And once the departments receive it and review it, the public also gets an opportunity to weigh in on the certification process through a separate petition process where the public can engage and say, we really don't think you should approve certification of this entity because I know that here are the issues where I feel like they are not fit to serve. And so there is a bit of public engagement prior to certification, as well as ongoing public engagement to ensure that certified IDR entities are fit and able to make determinations under the federal IDR process. The rules also, in addition to the federal IDR process, provide some guidance around federal external review. I think Matt touched on this just a little bit because it was addressed a little bit in IFR 1 also, but it implements the No Surprises Act provisions relating to external review and expanding the scope of that process to account for additional protections that are available through the No Surprises Act. And with that, I'm going to turn it over to Deborah.
Thanks, Elizabeth. So in addition to the protections for consumers who are covered by private health insurance, the No Surprise Act also included provisions for folks who are uninsured, or if they have health insurance through individual group-based coverage and decide not to file a claim. We call these folks self-pay individuals. Specifically, the No Surprise Act requires providers, healthcare providers broadly, to provide a good faith estimate of expected charges when an individual schedules or requests an item or service. So for instance, you are going in for a knee surgery. Upon scheduling that knee surgery, at least 3 days in advance, your provider or facility is required to provide you with a good faith estimate. In this good faith estimate, it must include that primary item or service, so the knee surgery, and then any other items or services that are part of that episode of care. So generally, you would probably need anesthesia, so the expected charges for anesthesia would be included in that good faith estimate, as well as any other items or services that you are expected to have during that period of care, the term we use in the reg. The scheduling provider is supposed to work with what we call in the regulation co-providers and co-facilities, so that all the estimates are included in the one good faith estimate provided to the consumer. Also in IFR2, we establish a process for uninsured or self-pay individuals to initiate a dispute resolution similar to what providers and plans and issuers have available to them. There's no plan or issuer in this situation, so a individual may initiate a dispute if after receiving the items or services, their bill is significantly in excess of the good faith estimate. And in the IFR2, we define substantially in excess as more than $400 of the good faith estimate from a particular provider or facility listed in the good faith estimate. The regulation outlines sort of the steps that need to happen, and similar to the IDR process that Elizabeth discussed, we have certified and contracted with independent dispute resolution entity. They're referred to a selected dispute resolution entity in the reg, who will review the bill, review the charges and the good faith estimate to then make a determination of a payment amount. I know we are limited on time and we have some questions, so I will sort of leave it there for folks to jump in with questions as we go. How does that sound, Brady?
That sounds great. Thank you, Deborah, Matt, Elizabeth, Lindsay. So we're 30 minutes in and we've got another 30 minutes. And I was figuring, typically we have very few questions and we let all the presenters answer that question, but I think it might be easier because we have a lot of questions, maybe to do a lightning round, and I'm gonna quiz myself to see if I send it to the right person. How does that sound? Good? Okay. All right. The first one I think is, we've got a few that are related to patients or beneficiaries. And I think the first one I'm gonna send to Matt, if you're okay. It's if a beneficiary is balance billed, what can or should they do?
Thanks, Brady. Well, the first thing a beneficiary or participant should do if they're balance billed is contact the provider or facility in question, and if it was mistakes, it can be corrected. Even if the individual has already paid a bill, the provider or facility can still avoid civil monetary penalties by reimbursing the beneficiary with interest for that payment. So that would be the most pain-free way probably to fix the problem. The regulations do set up a complaint process that can be used by participants and consumers to complain about provider practices. And that would be a way to bring a problem to the department's attention, to CMS attention in particular, but that will take a little bit longer. So the easiest way to solve a problem with a unlawful balance of surprise bill would be to flag it back to the provider facility and say, this appears to be incorrect, can you fix this?
And if I remember correctly, the information should be shared in a disclosure, kind of like the HIPAA forms that we get when we go to a doctor's office that give that information to the patient as well, correct?
Correct.
Okay.
The patient should be informed up front about the patient's rights.
Okay. Thank you, Matt. I think the next one, I'm going to try to move it around a little bit. Deborah, I think I got one for you. We heard a little bit about ID cards and that they may need to be updated to reflect this, and there was some discussion about that in the legislation as well. Should beneficiaries expect updated ID cards to reflect the provisions from the No Surprises Act and the CAA?
Yes. So more specifically, beginning for plan or policy years that begin at January 1st, 2022, begin on or after January 1st, 2022, plans and issuers are required to provide ID cards, whether physical or electronic, that include information about the beneficiary or participant's cost-sharing requirements, such as their out-of-pocket cost maximums and deductibles, as well as a website and telephone number where the participant can receive more information. There is not information about these ID cards in any of the rules that we've released yet. We did release a FAQ that included information about our intent to do future rulemaking around these provisions. However, plans and issuers are still required to update the ID cards with this information for the next plan year.
Deborah. I did have one question come in from the audience, and so I don't know who, this one I may have a harder time with. This is one of the challenges for a provider is that they don't always know what type of insurance someone has, but I do know that we expect them to gather that information. And so it's almost impossible for a provider to know if the state or the federal law applies. And there are some cases where they don't fit together perfectly. Have we thought through the scenarios, and will there be enforcement leniency in these situations? And so I had an example given to me recently where a provider, where the federal definition of emergency care may differ from the state definition of emergency care in their surprise billing legislation. Would providers have to be prepared to follow two separate processes depending on what type of emergency care it was? Does that question make sense?
It does. I can jump in if others want to. So yes, we have definitely heard this concern, and it's a concern I can tell you that states are really thinking hard about because they recognize that this can present a challenge. We're working very closely with states to sort of think it through, and I think this is one of the areas that may be challenging, especially in the first year. To the extent that a state law is narrower in how they define services, the federal laws are going to provide a floor. So if for example, the state law doesn't provide protections for post-stabilization services, the federal protections will apply. So from the provider's perspective, if the state laws are narrower than the federal, they should really be looking at the federal and knowing that they cannot balance bill anyone for the services that fall within the federal provisions as long as they're enrolled in the types of coverage to which these protections apply. It does certainly get trickier, and Deborah may have more to jump in on here in terms of if the state has additional protections beyond what the federal law has, or if the state has a specified state law that applies to some of the items and services that are subject to these protections, but not all. However, from the provider's perspective, it really starts with whether or not they're allowed to bill somebody. So they can kind of focus on that, I think, as a threshold. And ultimately, a lot is on the planner issuer as they kind of have to determine whether or not they're determining cost sharing based on a state law or a qualifying payment amount or an all payer model agreement. I understand providers will want to charge plans and issuers, but it is the planner issuer will have to do that initial determination.
And there'll be information, and we're kind of building the plane as we're flying it, so to speak. But there's going to be one thing I give CMS credit for, and DOL and Treasury, is that we provide lots of good information. So I know CMS has got a great presentation on the No Surprises Act on its website. It's got a website for No Surprises, cms.gov/no surprises, where you can have some more information on this. And DOL has some FAQs on the first interim final rule as well that are very helpful. So Lindsay, I'm going to stick with you. I think this one is you can help out with. It's so one of the questions we got is, can consumers opt out of these protections? So for example, a patient wants to a doctor who network, and that doctor is going to refuse to accept an in-network rate or the QPA. Can the patient opt out of that protection?
The answer is it depends on the item and service and the provider in question. So these protections apply in all instances for air ambulance services that are provided by a non-participating provider when the service would otherwise be covered. So if you cannot opt out of those protections with respect to those services, you also can't opt out of it for emergency services, with the exception, and I mentioned this briefly earlier, but didn't go into a lot of detail, for a subset of emergency services that we refer to as post-stabilization services. So after an individual is stabilized, if they meet certain additional conditions, then they are able to opt out of the protections. And then there are, in the non-emergency context, it's, I think, a little easier. You don't need to meet those additional conditions to opt out of the protections. So you could easily imagine that, imagine I have a significant health condition that I really want to see a particular specialist, and I have the resources and can go to that specialist. I may very well want to sign to waive my balance billing protections, and the statute and our implementing regulations allow for that. So I could say, go to a particular surgeon and see that surgeon. But the rule and the underlying law provide additional protections there so that you can't waive absolutely everything. So we know that people often receive, or one of the areas I should say where surprise billing is most common is with specialties where the individual has really no control. So they go in for a surgery, they make sure the surgeon, they make sure the facility are in network, they don't check about the anesthesiologist. There are certain ancillary services like anesthesiology where you cannot waive your consent. There's sort of an assumption built into the law that these types of services are not an area where you'd be able to waive them. And so you can't in those instances.
Well, Lindsay, after two great answers in a row, I think I'm going to give you a little bit of a break, and I'm going to ask Deborah a question. So if I'm a provider and I want to know if there are toolkits or resources or a website where I can get more information to kind of make implementation easier, is there a place to go and are there resources available to them?
Right now, there's no toolkit per se, but we did put out model notices and standard notices for providers to use around the good faith estimate for uninsured consumers. There's a model notice that providers aren't required to use, but if they want to ensure that they are following the rules and the protections, then we would recommend that they do use it because it has all the elements that are required. Similarly, for the IDR process and the notice and consent that Lindsay mentioned, there are required notices that must be provided or used as part of those requirements. And so as long as the provider or facility are using these required notices, then that's one level of assurance that they are following sort of the rules and the standards. We will be doing technical assistance and providing webinars and listening sessions and such for providers. And as you mentioned, Brady, we are building the plane and flying it at the same time. So I would definitely encourage folks to follow or check into that No Surprises website every now and then. We also have a listserv for federal IDR questions where we send out information about webinars and such. So that will be another resource for folks
I'm writing
to learn more.
I'm writing the website now and send out to everyone in the text. All right, so I've got another one that came in, and this one is, one of the things that, and many of you touched on this, or the good faith estimate, and I understand based on the Q&As that there's a little bit of the enforcement discretion. Everything is still applicable plan or policy year January 1st, 2022. But for the good faith estimates, especially for those practices and facilities that need to gather data on other practitioners in cost into the estimate, I think someone asked, given that estimating the charges for other related items and services provided by other facilities will be a challenge, is there a plan for enforcing the good faith estimate? What is the plan for enforcing the good faith estimate provision? Okay.
I could talk a little bit about this, and then Lindsay, if you want to jump in on the enforcement piece at all. So in the regulations, we outline that in year one, we will not enforce or take enforcement action on a provider if the good faith estimate does not include the expected charges from what we term co-providers or co-facilities. Others might think of them as ancillary providers. So in my example before, related to a knee surgery, if you're getting the good faith estimate and scheduling with the surgeon, in year one, if the good faith estimate does not include, say, the physical therapy that you are supposed to get while you're in the hospital, we would not take enforcement action on that provider for year one. Going forward, year two, that information is required to be included in the good faith estimate. And then again, we are going to be working closely with providers. We understand that this is a big shift for many providers, and so providing technical assistance, and you get it wrong once, we're here to help to try to bring folks along so that we're all understanding. But I don't know, Lindsay, if you have anything more to add there.
I think you covered it. Unless Brady, if you want me to talk a little bit about kind of the general enforcement approach, I'm happy to.
That would be great if you could for a little bit.
When you're thinking about providers and facilities, this is the rules are the way it's set up is that the states have primary enforcement authority, and then HHS comes in if the state is opting not to enforce, which for many states this is moving very, very quickly. Not all states are set up at this time. We hope that we reach a point where most states are doing enforcement, but at this time, we're working very closely with states to determine which ones are able to enforce these provisions right out the gate. And in states that aren't, either they don't have if for some states they might not have the authority, but we're working with them to do what we call a collaborative enforcement agreement, where basically we work together to enforce. So the state takes the lead and we back them up if needed with the federal authority. In other states, we may take it on entirely. And so we're working with states right now to determine kind of how that split will occur. And on the plan and issuer side, we are a little bit more familiar with that process because it falls within the general enforcement oversight that we have for a lot of provisions, in particular those under the Public Health Service Act or in the code. So there we have split jurisdiction. We share it between HHS, the states, DOL, Treasury, and so it'll be following that general enforcement approach. With respect to issuers, it's the same kind of structure as I just talked about for providers and facilities, where if the state doesn't enforce, we step in to back them up.
Thank you, Linda. Actually, I think you answered one of our later questions, so that's perfect. And Deborah, I want to apologize to you. Actually, I smiled a little bit while you were talking, and it has nothing to do with what you were saying. It has to do with the fact that I wrote the Surprises Act, that you go to cms.gov surprises, which is absolutely incorrect. And Elizabeth kind of made sure everyone had the right link. And so thank you for that, Elizabeth. All right, so next question. Oh, and this is related to that, but I don't want to, Lindsay, I don't want to have to go over and over and over again, but I think this is about the advanced EOBs, right? So not only are these estimates supposed to come from providers, but there's also an expectation that plans and issuers have advanced EOB or explanation of benefits functionality ready on January 1st. And then there's also some enforcement discretion related to that to let them get those put in place. Is that correct, Deborah, I believe?
Yeah, so similar to a good faith estimate that an uninsured individual can receive under the No Surprises Act. The No Surprises Act also has parallel provisions for insured consumers, so that a provider must provide those same data elements that they're required to provide directly to an uninsured patient. They're supposed to provide that information to a plan or issuer for a patient who's planning to actually file a claim and use their insurance. And then that plan or issuer is supposed to use all the information that they know about the consumer cost sharing and where they are in the deductible and such, and provide an advanced EOB to their participant or beneficiary. In the FAQ that we put out earlier this year, we indicate that we are delaying enforcement both for providers to provide that good faith estimate to a plan or issuer, as well as the planner issuers, requirement to provide the advanced EOB using that information from the provider. Until we can engage in further rulemaking, we heard a lot from stakeholders, from both providers and from plans and issuers and folks in the IT development world, that a lot needs to happen regarding the exchange of that information. And so we will engage in future rulemaking related to the advanced EOB requirements.
All right, so I've got, this one should be a quick one, and I think this is for Lindsay. Matt, I want to get you in some of these. I'm gonna go to you next, all right? So do the No Surprises Act implementing rules apply to grandfathered plans? I think this is you, Lindsay.
Yes, they do.
Thank you. That's an easy one. I like that. So one of the most controversial pieces of the implementing rules is the qualified payment amount, right? The QPA. It's the median contracted rate by plan type and by geographic area. Is that right? Say that right? By particular market and particular geography. How will we make sure that health plans are calculating this correctly? And I think that's, Lindsay, it goes back to you, and then Matt's next.
Sure.
Sorry.
This one. So Matt already mentioned that there was, in one of the rules, we talked about complaints. We encourage folks to submit complaints if you have reason to believe the QPA has been calculated incorrectly. We also will be doing auditing regarding the qualifying payment amount. My hunch is that this is likely to be a combination of sort of risk-based. So when there is a complaint, obviously we're going to want to look into it, and assuming the resources that we may also be doing some random-based audits. But we're still kind of working that through. Obviously, this hasn't gotten into effect, so no audits have started yet. But that's something we'll be doing on an annual basis.
All right, and then Matt, related to the QPA, I got a question for you. So, if the QPA amount, this median rate, that if it's higher than the in-network rate, will patients be responsible for additional cost sharing?
Sure, Brady. It's a little bit tricky here. So the way I would put it is the patient can't be held responsible for cost sharing that's more than the patient would have paid if the service or item was provided in-network.
Okay.
But the QPA is essentially a way of setting what the in-network rate would be. So if the payer had some very low network rates, but a slightly higher QPA for a service and charged co-insurance for cost sharing, then the QPA would set the cost sharing rates for a service gotten out of network, because that would be as if the service is provided at an in-network basis with the QPA as the payment rate. One somewhat related point to make, though, is if the billed charge comes in lower than the QPA, then the patient would only pay up the cost sharing based on the billed charge. So there's no, if the patient doesn't get a bad deal based on a QPA that would be lower than what the provider would actually charge.
That's okay. Well, that's interesting. Well, I've got another one for you, and this is a big deal for everyone working in health policy, especially on the plan and issuer side. We all know that there's a very large health insurer that talked about doing post-payment auditing of ED claims and denying them for them not being emergency, having an emergency basis or emergent basis. And it really sent shockwaves through the national insurer world and the provider world as well. So given the fact that some payers have recently considered denying claims for ED care that it determined were non-emergent, do these rules impact whether or not the provision of a service in an emergency department is paid or not? I think it's for you,
These rules
Matt.
don't. Yep. These rules don't make changes per se to the standards for what is an emergency service, but in the preamble we do provide some more clarity about how payers should implement those standards. And one point we do make is that payers shouldn't be denying claims that come through an emergency room based on automated process only on diagnosis codes. So they're going to be denying claims. There has to be some prudent layperson standard analysis provided with those claims. The prudent layperson standard still applies. The substantive standard hasn't changed, but we are aware that some payers have been pretty aggressive about denying emergency room claims based only on the coding coming through. And the preamble clarifies that is not appropriate.
Especially, yes, under EMTALA. Okay, so perfect. I got a quick one for you, Elizabeth. What are the costs for participating in the IDR process?
Okay, thanks, Brady. Yeah, so there are two different types of fees associated with the federal IDR process. The first is the admin fee, and that fee is paid by all parties who are participating in the IDR process. So this will be, the payers, plan issuers, as well as the providers who will have to pay an admin fee. And then the second fee is the certified IDR entity fee. So this is the fee that you would pay for your arbitration services. We, in addition to the interim final rule, at the same time, we issued fee guidance. And we anticipate that this fee guidance will be updated yearly and will outline the exact fee amount, which could be adjusted from year to year. And so the admin fee for this first year will be $50 per party. And then the certified IDR entity fee is discussed as a range. And so the range that we have determined is the appropriate range is $200 to $500 for the IDR entity service fee. Now, I will note that the rules contemplate the ability of the IDR entity when seeking certification to get approval for a fee outside of that range. And so there may be entities that may be able to charge a little bit outside of that range, but certified IDR entities, whether it's a fee that's within the range or an approved fee outside of the range, will only be allowed to charge what we permit. And so that information will be available through that very helpful website you talked about, as well as through the IDR portal, which will be the system that a lot of people will see come online in January that allows payers and providers to initiate the federal IDR process.
Thank you, Elizabeth. So and we talk a lot about the IDR process because most negotiations are going to be between providers, payers, plans, and issuers. But there's also an SDR process. Is there anyone who would talk real quick about the SDR process? I think we're at 1:30. Oh, man, these things always go so fast. So if you'd like, we on LinkedIn we actually put out a compilation of the implementing rules and the new proposed rule. But there are other places on the CMS website to get more information. If you have questions, let us know. Or one thing, CMS and DOL and Department of Treasury are always very good about being responsive. So if you have anything, please contact them as well. Just be on the lookout because, as we said, we are building this plane as we're flying it. It's too important not to build well and to make sure that the protections are put in place in a way that serves us all. So does anyone have anything they want to say at the end, our presenters? I don't want to be the last word in case you want something else you want to share. Let me put it this way. All right, I'll make it fun. If you had one thing you wanted to share with people, like one sentence about the No Surprises Act, what would it be? One
Yay.
sentence. Yay.
Is that a sentence?
That works. Deborah, how about you? Does that work?
Yeah, but not one sentence, but I do want to put a plug in. Definitely check out the No Surprises Act page. We are starting to roll out various pieces of the IDR process. I briefly mentioned we're accepting applications 1/1/22. You'll see additional pieces related to that go online, as well as all sorts of tools. So, definitely do check it out and come visit it often because things will be updated.
That is a long sentence right there.
I know. That's why I led with yay.
All right, Deborah, where's your sentence?
This is an exciting opportunity for consumers, and it's a lot of work for providers, a lot of work for plans and issuers, a lot of work for us standing this up, and we're all in this together. So we look forward to your questions and engaging with you over the next few months.
Perfect. Matt, how about you?
Well, I think Deborah mostly stole my line there. What I was going to say is we understand this is very complicated and that there's going to be a lot of work for providers, facilities, and plans and issuers of health insurance coverage to stand this up and make sure it works properly. So don't hesitate to reach out to any of us or departments about questions you may have or concerns you may have, because we want to make sure this is implemented as smoothly as possible.
And Lindsay, you've been so great sharing your knowledge throughout this entire call. We'll let you have the last word.
I was going to just say ditto, but let me instead add something quickly to what Elizabeth said. So you may have noticed that we also released a memo yesterday, earlier this week, sorry, time is flowing together, that gives some instructions on how you might be able to fill out some of the fields for the notice and consent form, and also the requirements around disclosing information about balance billing protection. This mentions one other website, which is basically the one that you provided plus consumers as a site that you'll be able to fill in. Right now, this doesn't exist yet, but that's another thing to keep an eye out for. We'll be building a more consumer-friendly website down the road. Again, building as we're doing it, so it's not there ready yet, but that'll be coming, and we're excited for that too, because we think this is really important for consumers to understand their rights here.
Well, thank you so much, Elizabeth, Lindsay, Matt, Deborah. Thank you for sharing your time, your knowledge, and also your commitment to making sure this goes into place as best it can. It has potential to do some great for the people of the country. If anybody wants to see this presentation online, we're going to post it on our website so you can share it with others. And thank you so much, everyone. I give you back the rest of your day. Appreciate it.